Say in a few words and say it very slowly for us, if you will. What mic are you? Four.
Please bow your heads in prayer. Father, thank you for the relationships that we develop here in the Capitol, and the friendships, the ability to work cross party lines and have honest policy disputes with little animosity. Thank you for all the many blessings we've given and the opportunity to serve in these roles. And thank you for the public and their participation, as it's so vital to this process. Please be with those that are less fortunate than us, and keep us ever in your service. Amen.
Thank you, Senator Calvert. Also, good job. Wanted to give a shout out to the Metro Atlanta Chamber of Commerce for providing breakfast for the committee this morning. I appreciate you guys doing that. All right, we have a quorum. We will start on the agenda with Senate Bill 493. Senator Mullis. We are working off of LC 36516-7S. Is that what you have in front of you?
Bill so well, I don't need it. And I'd also, for any easy questions, I'd like to call up Vernon Lee to sit beside me. I can handle all the tough ones, but any easy ones, I'll let him do.
Mr. Lee, do you want to join him up here? If we can grab these sign-up sheets. Hold on one second. Let's get these sign-up sheets. All right, let's make sure
we'll explain it so well you won't need a copy. Thank you, sir. Let me commend you on the outstanding job you're doing today.
Are you working off of a substitute, Chairman Mullis?
Yes, we'll be working off the substitute. LC 365167S.
All right, you give us just 1 second.
Yes, sir.
That's not the one I see in our folders.
Uh-oh.
Where are you getting it?
We can work off whatever you have.
Well, let's do this. We're in the process of getting the substitute.
Yeah, you mean just back off a little bit and let somebody else come up?
Well, if you want to go ahead and tell us about your bill, and then we'll talk about the differences with the substitute. There wasn't anything too substantive about it, hopefully.
Well, this is all about, thank you, Mr. Chairman, this is all about timeshare estates. And the proposed legislation provides an additional method of foreclosure of the lien upon a timeshare estate provided to an owner or association under Code Section 443-109. I could quote that if you need me to. Okay, and then the legislation only applies to timeshare estates. It does not apply to standard condominium units or other real estate interest or transaction. It's just timeshare. Whoops. Mom, I'll call you back.
Is that all you have?
That's all I have. I mean, it's that simple.
Okay.
I mean, we're talking about a simple bill. Now, I know I'm standing before this extreme, impressive committee that we could argue about a colon or a semicolon or a comma or a period. But other than that, it's pretty simple.
So basically, yesterday we talked a little bit about tax sales, but now we're back in Title 44. We're talking about foreclosures on real property. A question that I have, and maybe your colleague to your right could help.
A simple question.
What is the reason we want to make this change to just apply to timeshares when it comes to foreclosure proceedings?
We're moving it to from judicial to non-judicial foreclosures is all just for the timeshares. And for instance, there's about 18 timeshares in statewide right now. Most of them are in North Georgia mountains. There's a few on the islands. And right now, for instance, that is one unit up in Helen. For instance, if they were to foreclose in the process,
you can pull the mic down just a little bit.
If they were to foreclose in the process they have right now on the units that are just laying dormant because mom and dad have passed on, the kids don't want them, whatever, it would cost right now for the full process $5.4 million just to foreclose, and that is just to get the titles back, because it is just a kind of a deeded week. It's not really real property, but it's just a deeded week. So there's the short answer. So it's economic, so the timeshares can continue to basically put the inventory back in to inventory to resell. No other reason.
It ties up a lot of property that could move on and be sold or whatever. Have you ever had a timeshare property?
No, luckily not.
I would recommend not.
I've had clients that have, and they're very difficult to get out of.
Yes, I had to hire a lawyer once,
Mm,
and proudly, let me say.
right.
I've had one for
We have a-
25 years, and we still use it, so.
We have a question for Senator Cowsert.
Thank you, Mr. Chairman. And that's where I was headed. How does this impact the ability to get out of one? If you're stuck with one and you're stuck with the property owners and management fees, does it impact that at all?
Well, if you're not paying on it, this would allow the timeshare property where it is to foreclose. So if you didn't pay on it like these other folks haven't paid, then they could just notify you, do the 4 weeks of advertising, sell on the steps, and then you're out of it that way. By doing it to the non-judicial, opposed to the way it is set up right now.
How does that impact any deficiency that you might owe? Does there need to be a confirmation process to do that, or not?
These are units that sell anywhere from between $500 and $1,500. There's no owing, there's no debt. You pay cash or you don't own one. On these are, like I said, these are not like real estate or condos or things like, for instance.
What
But
if
as far as this is only applying, and it does not address whether somebody remains a member, Chairman, or they are having bills, or how they get out of it. This is just basically allowing the timeshares across the state to foreclose in a non-judicial process opposed to judicial.
But that also gives them rights to pursue their deficiency, and can't that include accrued homeowners fees that have been unpaid?
We're not. This is not doing that.
I'm getting that.
No, sir. No, sir.
And that's the
not at all.
biggest surprise of any timeshare is all the fees that are,
Yeah, not at all. Not at all.
unless you want to make it that way.
My church was gifted one at one time, and it became the biggest albatross we ever had.
Oh, yeah.
Because we accrued all these fees, couldn't sell it. We would have been happy to have been non-judicially foreclosed upon if somebody would take it off our hands and not assess 10 years of,
Right.
homeowners fees. And I want to be careful that people don't end up having a huge indebtedness without having been able to go through the judicial process.
And that's available, but it also keeps it where they can just get rid of it.
Chairman, thank you for clarifying that, because that does not. This will make it where they can just take the units and give the notices and go buy whatever on the steps and not go through any kind of back fees or anything owed at all.
Okay.
No, sir.
But a question on that. So if there is a deficiency still owed after the proceeds from the sale are applied towards the lien, could they not still go and pursue the balance of that?
There's
amount
no
owed?
balance.
What if there is? There's not.
This won't apply to it, so I can't answer anything outside this, outside the scope of this legislation. But for instance, this place which is the largest one in Helen I'm speaking of, they have over 4,300 members, and there's no debt there. I mean, like I said, there's no loans, there's no debts or anything, and there's no back fees at all. So it's not like, well, you haven't paid in 8 years, you owe 8 years worth of your annual maintenance fees. Nothing like that. It's just pay your annual dues. But this legislation does not get into any of that. And there's no back fees.
But there have to be back fees owed in order to foreclose, right?
You can just not pay your fees. Like if I didn't pay mine this year,
Right.
I couldn't use the facilities. And then technically, when the year rolls around, or past my week, then I would technically they could qualify to foreclose on me with this process by notifying me and be done with it. So I wouldn't have to go back. I just wouldn't get to use the facilities, and I would not have to go pay my annual fee, which is $500 just to get out of it. No, sir.
So my understanding, the way it works on foreclosures with mortgages now, if you want to seek the deficiency, you have to go and confirm the sale and have a hearing in Superior Court and proving the fair market value that was obtained at the sale. And then a court would determine whether or not that was the right amount, and then the previous owner would still owe that deficiency. Does this have any impact on the requirement of confirming a sale?
Does not apply to anything that you just said, and please don't make me repeat that. But it does not apply at all to what that thought process.
This is an easier way to get rid of the problematic
Right.
It keeps
timeshare.
people from doing what Senator Cowsert was saying, that this will just take that off of them. So if they haven't, and what's happened is timeshares are, biggest question I've gotten is, do we still have timeshares? And when folks bought this unit, this property is 40 years old. So when these were first bought, and built. Mom and dad bought them. They've passed on. They don't want them. The kids are not liable for them. The kids are adults, of course, and they just let them sit. They just ignore it, and the properties want to just have a way to get them back without having to bankrupt or having to go get anybody's money other than just get the property back with no other kind of excess fees at all.
Any other questions from the committee? Senator Kirkpatrick.
I just want to be sure I understand. So if the foreclosure happens, then the association dues stop and any fees going forward would stop?
Yes, ma'am. You would owe, because the foreclosure would be because you hadn't paid in anywhere from 1 to 40 years, and it just lets the property get the money back by, if you hadn't paid in a year or 8 years, you'd be notified by certified mail, which is in the law, and you would also get the 4 weeks of notification in the papers, and then it would go to the courthouse steps, and
And the family would get out of it, and then they'd be allowed to sell their property or the
That's-
timeshare to somebody else.
that's it. Nothing else in it, only applicable to the timeshare properties.
Any other questions from the committee? Senator Watson.
So we have the substitute now. Can you just sort of take us through any differences between the original bill and the substitute? Because I don't think the,
No, we don't have it. I don't have it. I just have the one that I,
Is that the LC 35167S?
yes.
Okay, he's got it right here.
oh,
Okay. My copy.
Yeah, if you could walk through the differences since it was not in the folder when you were presenting it.
yeah, we'll have to look and see first.
It's right here,
All right,
page 2.
page 2, line 24, 25, section B. Provided in writing to any lien holder sent by registered or certified mail or overnight delivery, returned receipt requested. And then the other one is line 34.
36 and 7.
Well, in the middle of the line, is that not it?
No.
Okay. 35, right after the word first, in accordance with the lien properties set forth in paragraphs 1 through 4 of subsection A of code section 44-3-109, after which any remaining proceeds shall be applied. That's it. That's the only changes.
So-
between them.
Okay.
And that is the language that the banking industry asked to have put in the bill, and I think they have a representative maybe here today that could, but that's why that's put in there. The bankers
So
asked
do you
to
want
put
to
that in.
let them explain what that means versus, I don't know whether they're signed up or not, or do you want to explain what that means?
Well, of course, the 2425 is just talking about it has to be certified mail. And then
They
the
get
other
their
one
money
just
first.
verifies the codes, which would be applicable to the banking industry. I don't have the code book in front of me, but I know that with all these lawyers, that's all been.
It looks like you're just confirming notice will be given to other lien holders and
That's right.
then the proceeds will be distributed based on who has the priority lien.
Yeah, so
I
the
think that's-
changes because of the banking industry.
We're good.
I can't make up any better than that.
Any other questions from the committee? No one else signed to be heard on the bill, so I guess the only ones that had questions were us.
I know,
So
and let me thank you for all those questions.
I made a bunch of them up and sounded decent, I think.
It's okay.
Senator Hatch, you make a motion?
Motion to pass.
We have a motion to pass by committee substitute LC 365167
Yes.
S. We have a second from Senator Rhett. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous.
Thank you.
You're on to the Rules Committee. Hopefully you have some
Let me
pull
know what
there.
I can do in my little old committee for the members of this committee.
Yes, sir, we will be.
Thank you, Mr.
Thank
Chairman.
you.
Thank you.
Thank you. Is Representative Leverett here? He is not. All right. Representative Leverett is not here yet. I think he was presenting elsewhere. The only other bill that was for action today is Senate Bill 500, which is my bill. So I will move forward with presenting on Senate Bill 500. With Senate Bill 500, I'm working off LC 490881S. Does everybody have that one in their folders? And this bill, what we're doing is there was a settlement reached last year by our Attorney General's office, along with our local governmental entities that were doing suits based on opioid use in our state, something that's happening around the country, these lawsuits. As part of that settlement, we have to put, well, we don't have to, but what we're trying to do is put into code basically a release from all other claims. What this bill is doing is confirming that once the settlement has been reached, which is defined in the bill itself in front of you, once you get past line 32, you get into meet a bill line 33, you see us define governmental entity, you see us define what a release claim is, release entity, and then define what the statewide opioid settlement agreement is on lines 47 through 61. What we're doing is saying once that agreement has been reached, we have a waiver of any other claims that could be brought by other governmental entities in our state. In other words, in order to maximize the amount of the benefit we have from one settlement at the state level, we have to make sure we're not going to have other governments coming back in, counties or cities or even the state, and having other litigation. What this does from a dollar standpoint, the numbers I've been given that the state of Georgia will receive with this settlement is $636,230,843.82. If we don't have this litigation bar, we're looking at $143 million less. And so this is a way to maximize the amount of settlement that we get for funds in our state. And there's some questions I've been asked about, where is this money going? Well, all that is set forth in the agreement that we have in the settlement itself that's already been signed onto. And the way this is going to work is the funds go to a trust. There's basically a process in the settlement where that money is dispersed around the state in different ways to help go back and deal with the challenge we've had in our state when it comes to opioid use and abuse over the years in our state. That's what we're doing with the bill, and there are people here from the Attorney General's office. If anybody has any other questions about this lawsuit, this settlement, and what we're trying to do with the bill. And with that, I will open it up for questions. Senator Kirkpatrick or Watson? Kirkpatrick.
So, Mr. Chairman, isn't it true that one of my counties had a pre-existing lawsuit and is that addressed in lines 72 through 78, the bellwether section?
Yeah, so in Cobb County, you still have the ability to do what's called bellwether claims, where even though we're releasing all the other claims in the state, you'll still have the ability to do what I would almost call mock trials, if you will. It's probably a better way of putting it. But that provision there allows Cobb County to still participate with these bellwether claims and trials they could have with the outstanding litigation that's there. Senator Watson?
Just for clarification, this is a one-time, and could you give me a 30,000-foot view of how the money is it designated what it has to be done? It is designated and for opioid abuse and so forth.
Right.
Gotcha. Okay.
And so yes, it's a one-time thing because we're clearly defining what the statewide opioid settlement agreement is. If you look on line 54, it even has the date that it was entered into by the state. And so the way this works, there'll be an agency head appointed by the governor that's going to oversee a trust and disperse the funds to different regional advisory councils around the state. So you have some money that goes to certain regions of the state. You'll have other money that's held back at the state level. All this is set forth in the settlement agreement, which is public record, which the committee can get if you'd like as well. And if you look in the bill itself, you see in lines 17 through 32 in particular, you look at, really looking at lines 17 through 22 in particular, you look at what we're doing with the funding, prevention and treatment of opioid addiction, resources to law enforcement agencies to address the opioid crisis, trying to increase the number of professionals who provide treatment for opioid addiction, educate medical professionals regarding the safe and effective prescribing of opioids, and more treatment and prevention money for people incarcerated in our state as well. But again, if you want more details on exactly where the money's going, that is not something that's in the bill itself. It's not something we have the authority to do with legislation itself, but it is something we can get more information for the committee on. Senator Hatchett, or is it Senator Kennedy? Senator Kennedy.
Yes, sir. So what is the purpose and utility of the bellwether claims? If that's brought, what, I don't know, I don't understand that part.
Yeah, and someone may can explain this better. I've never done that kind of claim, but apparently it's a way that other lawsuits that are pending around the country could still use that action, and the example was given in Cobb County, to still have trials to look at things like liability, potentially lead more towards settlement by seeing how a jury will respond to that claim being set forth. It's a way with a bellwether claim to, I use probably the wrong terminology, almost like a mock trial in a sense. But it's something that was requested by Cobb County, and frankly, it wasn't in the original bill, and that's why we have a substitute, but it doesn't hurt what we're doing with the bill because it still settles all the claims in Georgia, all the substantive claims. But if
Okay.
you want a better answer, I'm sure somebody in the Attorney General's office can give a better answer than I gave. Would you want? Yeah.
Speak for a moment.
Yeah, if you'll introduce yourself. And
Sure. I'm Wright Banks. I'm the Chief Deputy Attorney General. Senator Kennedy, the purpose for carving out the Cobb claims, the Cobb bellwether claims involve different defendants than are the subject of the statewide opioid settlement agreement that is before us right now. Those bellwether claims involve retailers, and there are no retailers in the statewide opioid settlement agreement. So it's designed to carve that and protect that case so that it can go forward. Okay. There could be another
Thank you.
bellwether claim in theory, but the primary one that everyone knows about is the Cobb case.
Okay, thank you. Thank you, Mr. Chairman.
logistically, one thing I've done incorrectly, I need to designate somebody to serve as chair while I'm presenting. And so, Senator Cowser, I think you're still the vice chair, aren't you? I'm going to turn you on.
Thought I'd been demoted when you sent me down here.
Well,
Made me
because of
say
that
the
comment,
prayer.
I'm not going to give you the chair up here, but I'll let you start taking the questions. So he will now take over with questions.
All right, anybody have a question? All right, if you'll recognize number
can't see the
7.
Yeah,
Hit-
number 7.
Hit number 7, you're recognized, Senator.
Thank you. Yeah, right? Yeah. You're definitely in the catbird seat. Okay, sorry I walked in a couple minutes late. I just have a few questions. So can you back up for me just a little bit? This is a result of a multi-state settlement with these two, several companies?
That's correct. There's 3 distributors, Cardinal, McKesson, and AmerisourceBergen. And then there's one manufacturer, which is Janssen
Johnson & Johnson.
Pharmaceutical,
Okay.
which is a subsidiary of Johnson & Johnson.
Okay.
There's 50, I believe there's 52 states and territories that have signed on to the agreement with the distributors and 51 states and territories that have signed on with the agreement with Janssen.
So it's a condition of, there are certain conditions, and if so when you say 51, that means, is that all the states, or how many territories
It's
are we talking
almost
about?
all the states and then a few territories. There are a few holdout states and states that made different deals at different times.
So why would those states not sign on, and what's the benefit to them for not doing so?
There are some states, for example, West Virginia, as I recall, made their own deal at one point.
Because they had a significant problem and maybe
Pro-
got out ahead of it with their LG, or what?
Or probably had a trial date. That's my memory.
Well, I remember that, certain states were really aggressive early on in trying to jump on this type of thing. And I probably don't remember all of the litigation, but I remember Oklahoma being out really
Correct.
in advance.
Oklahoma
Maybe
made
West
a
Virginia
deal.
was another.
I think that's right.
Did we do anything like back then, or no?
We didn't make a settlement then, but we've had active litigation with the 3 distributors.
When was that?
We've
Filed, do you
been
remember?
in that litigation at least a couple of years,
Okay.
maybe 3. But
So now the posture that we're in, since explain to me the benefit to Georgia to do this versus continue with the other litigation?
well, we would
That we've had for 2 years?
We will continue with our litigation that's
Okay.
pending in the Gwinnett Business Court with some other defendants. There are other non-settling defendants, but the national settlement that's been sort of put in front of everybody, the scale offered in that settlement and the amount offered in that settlement is sort of a one-time opportunity to make a deal with these companies. What's going to happen, if I were making predictions, what is going to happen is those that don't settle with the distributors or don't settle with Janssen, my gut is they're not going to get a more favorable settlement. And those companies are going to litigate those remaining claims pretty hard. And you know, you have to take your chances.
Yeah, sure.
So-
Can I ask one more,
Sure.
Mr. Chair? How many other states are doing legislation such as this?
I don't know the answer to that, but a litigation bar is the key to maximizing the recovery under these settlements. It takes the number, if you don't pass a bar, it takes the number immediately from 636 million down to high 400s, so about $150 million cut. And then you also have to deal, though, with the potential over the lifetime of the payment stream. You have to deal with the potential for them holding back payments if other local governments litigate.
Thank you. Just wanted to understand it all
Sure, I
a little
hope
better.
that's helpful.
Appreciate the answers.
So basically, they're willing to pay more if they know they're extinguishing all the claims from the state because you're barring the municipalities. Otherwise, they're going to pay part of the state, and they may also have to be paying to various subdivisions of our state.
You have it exactly right.
Okay.
They're going to pay us less, and then they're going to retain the right to hold funds back from us if local governments litigate.
Right. Thank you. Any other questions from the committee members? All right. All right, I recognize Senator Watson for a motion.
Like a motion to do pass.
Is there a second? Second by Senator Kennedy. Any further discussion? All right, all in favor, raise your hand. And any opposed, like sign. All right, passes unanimous. Thank you. I turn the gavel back over to you, Mr.
All right,
Chairman.
thank you. And there was no one else signed to speak on the bill, too. All right. Now we have Representative Leverett here. If you want to come on up, we have House Bill 1361.
Thank you, Mr. Chairman, members of the committee.
Good morning. We were working off of LC 365144. Is that correct?
That's correct, Mr.
Okay.
Chairman, to my knowledge.
All right. The floor is yours, Representative.
Thank you, sir. Well, good morning, everyone. I appreciate this opportunity to bring before you for your consideration House Bill 1361. This is a bill that kind of, I guess, has a bit of a personal story associated with it. My father, Freeman Leverett, was started out his legal career. He was a lawyer in Atlanta back in the 50s working for the Georgia Attorney General's office. And later in his career, he actually had litigation over the code section that's the subject of this. When he was a private attorney, had some litigation over this code section. According to him, the genesis of the code section was Alfred Evans, I believe was his name, who was an attorney with the Attorney General's office for many, many years. And he would just get spitting and cussing mad when he would get a lawsuit that had been served properly on a state agency, but it wasn't getting to the AG's office until about 45 or 60 days after it had been served, which is, as those of you who are lawyers know, that means the answer had long been due and they were in default currently. So in the declaratory judgment code, they added this code section that said, if you're going to sue the state and you're challenging some act of the state, you need to notify the Attorney General when you do so. So it gives the Attorney General a right to be notified timely so they can take action if they deem it necessary. And so what I've done is just sort of clean the statute up a little bit and made it clear that the Attorney General is not obligated to appear. I know their resources might be stretched thin and they may not feel it appropriate, but they at least would have to be notified and have the right to appear. It makes it clear that even though it's in the declaratory judgment code, it applies to any kind of action. And they can the AG, if they deem it appropriate, can appear. They're not mandated, but they can appear. And so it gives the AG's office some discretion in that regard. And that's really the extent of the change, Mr. Chairman.
And this bill passed the House recently?
It
Is that
did,
correct?
yes,
What was the vote in the House?
I don't recall, but I think it was, if not, we had some excused absences that day, but it was very close to everyone who was present. I don't think we had any votes against, actually.
Completely.
Yeah.
In the
And
pos-
it
no
does
votes.
also, it makes it clear that it applies to, any statute or act of the General Assembly.
All right. Any questions for Representative Leverett on House Bill 1361? All right, no questions. There's no one signed up to be heard on the bill. What's the pleasure of the committee? We have a motion to pass by Senator Cowser, second by Senator Kennedy. Any discussion? All those in favor of the motion, please raise your hand. It is. It's unanimous. All right. Thank you very much. You'll
Thank
be
you so much.
on to rules.
Appreciate the
All right,
committee's
thank you.
consideration. Thank you.
Senator Dolezal, you were next on here, but Senator James had to be somewhere at 10, I believe. If it's okay, I'm going to call her up first. Senator James, you want to come up with Senate Bill 154? Good morning.
Good morning. Thank you very much for
you're
this
good.
hearing.
Yes, ma'am. So we're working off of LC 412868. And I will turn the floor over to you.
Good morning, everyone. I have had 4 hearings in my district over HOA members who and former HOA members. 2 had lost their homes because they, during the pandemic, were unable to pay their HOA fees. And it got up to like $20-something thousand worth of fines and fees, and they took their homes. And then there were others. I had at least 25 people who made testimonies during these hearings who had other problems because, one being that the water was coming down from where they built the house and flooding their yard and their basement. And they kept calling the county, the HOA owners, and they never got any results. And then he decided to stop paying his HOA fees. So as a result, his fees just a month ago were $11,000, and they were about to foreclose. When I asked the county of the Douglas County to come in and look at it, and when they did, they realized it was one of their problems. So, but it wasn't their problem that he didn't pay in retaliation of not having the HOA to come and satisfy the problem. Anyway, those are the kind of things that happened that inspired this legislation. So I met with Representative Bodie over in the House, who also represents that area. Then I ended up finding out that the Fulton County portion of my district also had problems, and the Commissioner Arrington worked with me, and we had another hearing, and 200 people came out. They were all upset about their HOA fees, and they had the HOA never put the tennis courts or the swimming pool or different things that they promised, the bike trail or anything, but they were continuing to charge them. And so some of them stopped paying the fees, especially through the pandemic when they were not at work and things were strained. So now they're about to, the fees become so high that they can't, now that they've gotten some other job, can't take care of them. So I wanted to do something, and Bodie and I looked at also having a committee, study committee. So over in the House, he's working on that. And this is the portion that I wanted to work on so that the fees would not be so enormous that they lose their homes. So many homes, and when I say many, I think that 33 homes from the Fulton County portion of my district, as well as Lithia Springs and Douglasville, have been taken by the HOAs in just 3 years. So I wanted to look at this let's see, which is it, Chapter 3 of 44, and try to add the wording. And so that's why I'm here today, to see if there's any way that we can help homeowners who are strained by no fault of their own sometime, or they're retaliating against this HOA. Already they're paying a large fee, and so we looked at the fees that HOAs are paying all over the state of Georgia, and somehow in the Fulton County and the Douglas County, they were at least about 10% more, all the way up to 25% more than the normal, the regular amount that HOAs receive. So I think that if we add this into that section, that if the fees, are levied upon the house, it will be something that's affordable when they get the results that they need, because they don't need to lose their home. And I found out also that most of the houses that they're trying to foreclose on have a lot of equity, and some of them have lived there 12 to 15 years paying mortgage, and until they had the problem. And so, they've invested into the area, and so I hope that y'all can look at this and agree with me that this is a possible solution to the problem.
No, I appreciate it, Senator, and I understand what you're obviously trying to get at. The two challenges that I see, one, which in your bill you have an effective date of July 1st, 2021. I know that was from last year when you filed the bill.
When I put this bill in last year, a week later, I went in the hospital and I stayed there 6 months.
Right.
And in the nursing home 2 more months. So I've only been out 4 months.
Right.
Now. But yes, so unfortunately.
But I think the challenge is there are constitutional issues with going back and amending previous documents where HOAs were set up, previously recorded and agreed to documents. And that's why in the draft you have, Legislative Council has it where it would only impact future instruments that are executed and amended. And so the challenge is legislatively, if this passed, it still wouldn't directly help people who currently have assessments with HOAs. I don't know, the other challenge I see is how someone is to know what the mortgage cost is for a lot owner. And I know we tie it to what that is, but how someone who owns, or an HOA itself, like you're looking at here, so how the HOA would know what every individual owner has as far as mortgage cost as well. I think would be a big challenge as to how they would even find that out.
Well, they do. They have that. That's part of the contract that they have when the person purchases the home under that association. So they do have that information.
The mortgage cost itself,
And they have a percentage that they are supposed to give to each homeowner. And so the problem is this: you're about to buy a house, and it's a HOA, so you sign the home. You're closing, so you sign that. Many people don't know that they are liable for this, or they can take their homes.
Right.
So that's why we wanted to have the study committee and look at all the different problems and possible solutions.
Right.
And 2 of the county's commissioners have started this HOA boot camp, or whatever they're calling it.
Yeah.
But it's still no results. And they also like this particular bill because they thought this would at least slow down the problem now, and they won't have an $11,000 worth of fees in addition to the amount that they owe to the HOA. And if they say, well, I don't want to lose my home, then they're going to have to go and almost what they paid for it from the beginning is what they're going to end up with, a 10-year-old house. Or whatever.
Right. Do you have some questions from the committee? Is it Senator Kennedy? Or is it? Okay.
Mr. Chairman, and you addressed some of the ones I had, but just to maybe sort of while we're noodling on this, and thank you, Senator James. Following up on your comment, Mr. Chairman, about how would the mortgage cost be known, I think maybe a subset issue there would be, I'm not sure how we define, that would need to be a defined term. What are mortgage costs? And if that's going to be the metric used, I think we need to flesh that out. And then secondly, it seems to me there would be an issue if the statute would only limit the amount of HOA fees on Lot A, which has a mortgage, but Lot B, which is paid for and free and clear, and it would not limit it there. I think we've got maybe some constitutional issues there. I don't know if that's an equal protection argument, but some inequities there in how it's being applied. You got similarly situated people that are being treated differently just because one has a mortgage on their property and the other one it's paid for. I think that may be a problem as well. Thank you, Mr. Chairman.
Can I respond?
Oh, yes, ma'am.
Well, I think that may have come up in the hearing with Douglas County, the Lithia Springs area, and the realtor, what is it, Georgia Real Estate Association, they looked at it and they thought this was clear and that it would help. And they used the percentage, no matter what your house costs or what you're paying, or whether you own the property next to it or you're still paying on it. They thought this would relieve it. So this is what we came up with together. And these are people who work every day in this. So I don't know if I can look into that.
Okay, and I hear what you're saying, and you might want to make another run at it with them. And the using the term mortgage presupposes that there's a debt on the property, and so I think you have two paths you're going to have to follow there. So
It's a debt on most of the property because the houses are still being paid for. They're still under the mortgage payment, and not just for the HOA.
All right, any other questions from the committee? All right, no one else signed up to be heard today on the bill, Senator James, but thank you for bringing this to our attention. I know you said you're working on possibly a study committee as well, so we'll keep looking into this. But I appreciate you being here today with us.
Thank you, and I'm going to bring, I hope, the study committee, once it passes on the other side,
Right.
before you, and so I hope that we'll be able to really help all of the homeowners who have the problems with HOAs.
Right.
Thank you very much, everyone.
All right, thank you.
Okay.
Have a good day.
Okay, you too. Bye.
All right, next bill on the agenda is Senate Bill 485. Senator Dolezal. And we are, just 1 second to locate the bill. We are working off LC 280422. Is that what you have?
It is,
It's not
Mr.
a
Chairman,
substitute, is
thank
there? Right. All right, the
That's
floor is
correct.
yours.
Thank you. Good morning, Mr. Chairman, members of the committee. This bill is a work in progress, and the chairman and I have had some conversations on the floor regarding this bill, but just want to zoom out for a second and talk about big picture, what we're trying to accomplish here. And that is to have a threshold at which written agreements are enforceable, in which oral agreements need to be written down. Right, because there's examples. I've actually run into this in my own personal life, but this was brought to my attention by a friend of mine, wherein you have claims that can be made, or at least questions that can arise over formal oral agreements. And in my case, it was an equity position question where there was essentially a handshake agreement, and then you get 3 to 4 years into the business, and everybody has different memories of what the handshake agreement was. So this bill is simple. What we're endeavoring to do is to say that anything over a certain amount of money needs to be written down. And the conversations the chairman and I were having around what that number should be, I'm not tethered to this $10,000 number. This is just a number that we put forward. But The goal here would be to require something to be in writing at a certain value amount, such that if there is a question over an oral nature of an agreement, that if there was not something that was papered, that it would default to what was papered. So with that, it's literally, I'm sure you all get lots of bills here people say are simple. This is simple in concept. It's one line. Line 22 on the bill is where you see the change. And happy to have the committee's input or any feedback that you guys would have on this as well.
All right, thank you, Senator. Yeah, and while it does look simple, it is a big move. I don't know if other states have done this. I don't know the answer to that, but it would basically require every time you want to enforce an agreement where the word we use here with the value in excess of $10,000, you'd have to have that agreement in writing. It would basically preclude anybody from ever recovering from a verbal or oral agreement that they had with somebody. A couple thoughts from me. One is, I don't disagree. Maybe there's a policy, good policy to have it where you have large contracts that would tend to have more sophisticated individuals in them, and you would want people protected when a large amount is due. And so maybe there is an amount that's well over $10,000, given that even our small claims courts have the $15,000 threshold right now, where you'd want the agreement in writing. Another thought, though, would be the language. We have any agreement with a value in excess. It probably would be cleaner to say something such as any agreement where the consideration for the agreement is, and at least the initial consideration is, an amount that exceeds this amount. What I mean by that is you may have agreements where you started under some sort of agreement not in writing, and suddenly because of the practice, whatever you're selling, the business, whatever it is, over time, it exceeds $10,000, for example, your bill here. And so I think you want to look at the initial consideration for the contract itself too. But I think it's an interesting conversation to have. And I know I've mentioned it to our friends of the state bar, folks in the real property, not from the real property, folks from the contract section. Love to get some feedback as to how we best can do this, because I do think you make a great point.
Thank you for that feedback. I think what was interesting to me in looking at this was really looking at lines 14 through 21, which is the current agreements that are required to be in writing. And another idea that I had around this was maybe it was any agreement that involved equity in an entity that would really target kind of that specific piece of what I've personally ran into. I think the challenge perhaps with what you just mentioned that I'm trying to reconcile in my head is, startup businesses aren't worth anything. And so, and they don't even contemplate necessarily value oftentimes outside of sweat equity, because they're often just being bootstrapped. So I guess my question would be in that instance, what would you suggest to do? Because there is no value at that point, right?
Well, I would think most entities would have corporate documents that would, for example, give membership shares and set forward how the money is to be divided, right? Would that really come into play here? If
it's done correctly, it would. But I think a lot of startups, and I've been involved in them with friends, where you're just kind of starting something, don't know if it's going to make it. Hey, we're just partners. Mm-hmm. You then get to round, Series B of your fundraising or something, and there's a little bit of confusion around a cap table. And I think that's where those startups then can run into trouble if they haven't been properly documented along the way. So I think the goal of this would be to encourage people to
have corporate documents.
To have
really.
that, correct.
You have a question, Senator Kirkpatrick?
I know the IRS allows gifting up to a certain amount to family members. Would this impact that at all?
I don't think that this would impact that necessarily. I know they have that annual statute of what.
Yeah, and nobody has a written agreement.
Correct. But there also wouldn't be, if you scroll up to lines 11 to 13, it's what makes the obligation binding to the promisor, right? So it's basically what's enforceable should you have a dispute. And I don't think that would necessarily arrive under the apply under the IRS gift tax limitation.
Senator Watson or Kennedy? Who was Senator Kennedy?
Me. Thank you, Mr. Chairman. Thank you, Senator. This has sort of got us lawyers noodling on this and what all this might involve. And
the doctors, apparently.
And the doctors, yeah. Well, they're getting honorary law degrees by serving here. Obviously, written contracts are better. And I think all lawyers typically, depending on the circumstances, but with anything of any significance, advise clients that, you want a written contract. because what happens when conflicts arise, right? What were the terms? What were the ancillary understandings around that? But that's kind of what the courts are for, to sort that out. Hopefully, justice gets served through that process. My concern is an unintended consequence of, with this bill, if you've got an $11,000 contract, then the party seeking to enforce it automatically loses. They don't get their day in court. And if you think about it, the way things usually unfold, oftentimes it's the party that's been wronged is going to court, whether it's an $11,000 or a $250,000 matter. They're going to court to try to enforce the contract. And the guy that was smart enough to just sit down and say, no, we don't need a contract. Just don't worry about that. This is okay. He wins because the guy that needs to enforce it doesn't even get to go to court. So, I think we need to think through the broader public policy implications of how all that works as well.
Any other questions from the committee? All right. There's no one else that signed up to speak on the bill. Thank you, Senator Dolezal. We'll keep studying this and see if we can come up with some other ideas.
Thank you all.
All right. Thank you. All right. The last bill on the agenda, Senator Anderson, in fairness, I told her I didn't anticipate us getting there this quickly. And so she's on her way. She had some other meetings to be at. But there's some people here that want to be heard on Senate Bill 249, and Senator Jones has agreed to kick it off in presenting the bill, and then we'll call the individuals that are here to be heard on it. When Senator Anderson gets here, we'll let her come forward and answer questions as well, if everybody's good with that. So, Senator Jones, we're working off LC 412985. Your mic 6.
Yes. Thank you, Mr. Chair. So this is LC 412985, Senate Bill 249, which is a bill to basically split the judicial circuit, which is currently our COVID judicial circuit. The COVID judicial circuit is made up of Walton and Newton County. Under this particular proposal, Newton County will remain in the Newton County will become the Newton County Judicial Circuit, and Walton County will remain in the Alcovy Judicial Circuit. Because it would be a new judicial circuit as far as the district attorney is concerned in Newton County, one would be appointed. That date would actually have to be changed now by July 1st, 2022, and expire December 2023. It actually works out in this sense. You have 3 judges who currently live in Newton County, and so they will remain in Newton County and be the judges in that particular circuit, of course, until their next election. And then you have 2 judges who live in Walton County, and they would become the 2 Superior Court judges in Walton County until their respective election. And so with that, Mr. Chair, I'll allow the persons here to speak on it.
All right. Thank you, Senator Jones. And I won't make you answer questions from the committee. We'll hold. First person signed up to speak is Stephanie Lindsay, attorney. Come on up, Miss Lindsay. How are you?
I'm wonderful. How are you?
Good.
That's good.
Thank you for being with us.
Thank you for having me. I want to first thank the committee for even taking the time to hear this bill. I'm sure that some of you may know that this bill was actually presented in the last year, and unfortunately the bill has just been sitting. This bill is to allow for us as Newton County, which I consider the best county in the state of Georgia. I'm pretty sure your chairman will agree because he represents our county. Will allow us to have our own judicial circuit. This is not the first time that this bill has been presented to this legislation or legislator before these legislators. It was actually presented back in 2010 by our former representative, Robert Mumford, who is now our sitting Superior Court judge in Rockdale County. And he presented it back then for the same reasons we're presenting it now. When you look at the counties around us, excluding Walton County, counties that are similar to us, they have their own circuit. We want to be able to be separate from Walton County. Not that Walton County is a bad county, it's a great county, but for us, we want to have our own identity. This bill was presented last year, and it was presented along another bill that this committee has heard about, that is Senate Bill 9. Senate Bill 9 was presented And it was presented at the beginning of the session, and within a few short months, Senate Bill 9 had made it through this committee, made it through the Senate, made it through the House, and is now signed into law by our governor. On February 2nd of last year, our Board of Commissioners decided that it would issue a resolution to our Newton delegation. In that resolution, it asks for our delegation to vigorously pursue legislation to allow us to be our own circuit. That legislation was presented by our Senator Tanya Anderson, and as I stated, that bill was presented, I believe, on February 24th of 2021, and this is the first time that we've had an opportunity to have any movement on the bill since then. I don't want to speculate as to why that's the case, but I want to focus on why this committee should push this bill out of this committee so this bill can have a proper opportunity to be enacted as law. Senate Bill 9, which represents Columbia County, had a desire, by the will of the people, to be its own judicial circuit. In that, when you looked at the numbers that Columbia County had as related to the workload, as it related to the costs associated with creating its own circuit, it paled in comparison to Newton County. For instance, there have been 2 assessments done to tell whether or not Columbia County should sustain its own circuit. One of those assessments was presented by Senator Lee Anderson, and in his assessment, when he received back the information from Judicial Council, the Administrative Court of Courts, the assessment indicated that they were not of the nature, because of the percentage of workload that it would have, to even have its own circuit. I believe that the workload numbers were 90%. And that would have meant that the judges in the circuit would be performing the workload at a level of 90%, which is, not ideal for a county to have its own circuit. Even after that, we had Senator Harold Jones, I believe. He asked for an assessment as well to determine whether or not, that was in 2018, whether or not Columbia County and Augusta County and Richmond County and Richmond County and Burke County should separate, and how would that look if that was separated? Even in that assessment, the numbers did not allow for Columbia County to sustain its own circuit. When you looked at the actual cost associated with the establishment of Columbia County, the cost was excessive, because Columbia County did not act on its own already, with its own staff, with its own clerk, with its own district attorney, with a place to actually house the actual judicial system. The cost associated with that was tremendous. To be specific, Columbia County had to have a location found, a district attorney appointed. It had to also have staffing for the district attorney's office, and it also had to have staffing for a clerk's office. Even yet, through all of that, Senate Bill 9 passed. Now, some say that Senate Bill 9 passed because it was partisanship. And some say that Senate Bill 9 passed because it was a further attempt to disenfranchise black voters, which is a tough topic for all of us. I try to be very idealistic and I'm very much optimistic, and I say that Senate Bill 9 passed because it was the will of the people. Because Columbia County made it very clear that the will of the people supported them having its own circuit, despite the fact that a lot of people in the community, were against it, despite the fact that some of the judges were against it. Despite the fact that there were legislators that fought it, and despite the fact that it was not good based upon the empirical evidence, somehow this committee found it appropriate to pass it out. And I say you did it because you saw in the people that were presenting that bill that the will of the people spoke. And I'm submitting to you that as it relates to Newton County, the will of the people have spoken. The will of the people have spoken through this Board of Commissioners. The Board of Commissioners comprised of 5 districts, and those districts comprise of a panel of what our community is and the representation in our community. And that Board of Commissioners decided that it was time for us to have our own circuit. So let me tell you something about Newton County. When you looked at the studies that Tanya Anderson, Senator Anderson, requested on the actual judicial circuit, if we were to be on our own, the numbers speak that we should have our own circuit. We would be performing the judges, the 3 judges that are left, at a level of 100%. Not at 90, not at 80, 100%. And those numbers are based upon the numbers from 2019. Just imagine, with all the backlog that we have now, what those numbers will reveal. In addition to that, as it relates to the studies that was done, there was also a study that showed that if Walton County was separate or remained in the Alcovy circuit, Walton County would need another judge. And they would need another judge in order for them to be at 100%. So that's 1 judge that you would have to add as a cost for this split. Judicial staff that would have to be added. The additional cost would be associated with appointing a district attorney for Newton County, because the district attorney that we have now that's in place, District Attorney Randy McGinley, who is here in opposition, and who I will say for the record is a very good district attorney. I like him a lot. I consider him a great colleague of mine. We go to bat lots of times, but in the end, I know that he tries to be as fair as he can be. But that's not what this is about. So we would have a district attorney that we would have to have appointed for Newton County. In addition to a district attorney being appointed, we would have to have a chief public defender that would have to be appointed as well. That's it. Nothing else. We're comparing apples to apples. There's no reason why this bill should not be out of committee and enacted into law. Newton County and Walton County, for whatever reason, the powers that be, they were smart in the way that they set up the judicial circuit. Because the judicial circuit is already set up, split and separate. Walton County has its own buildings and its own staffing. Newton County has its own buildings and its own staffing. The only thing that's shared are the judges and the district attorney and the chief public defender. That's the only thing that's shared. Everything else is separate. I always, complain that their facilities are a lot better than ours because they have a beautiful building. We have had an annex to our building, but it still is not as plush and nice as Walton County. But nonetheless, everything is already separate. So it's not an issue where we would have to pay for that. In addition, the actual judges that are in place, we have 5 judges. Of the 5 judges, 3 already reside in Newton County and 2 reside in Walton County. That would not be an issue. The effective date now, since it would be changed, is perfect because it will allow for the appropriate amount of time for individuals to be appointed before the next election cycle. As I sat in the audience earlier today, I listened to the prayer. My husband says I don't pay attention in church, but I do. And I listened to the prayer of Senator Concert. And I want to just really highlight something that he said because it was powerful for me, and it actually gave me goosebumps when you said it, to be honest. And what you said in your prayer was that you pray for honest policy disputes. You pray for honest policy disputes. And what that means to me is that we don't look at white, black, we don't look at Republican, Democrat, independent. We don't look at poor, we don't look at rich. What we look at is the policy. And as an attorney, and I know many of you are attorneys as well, we all know that when we go into law or in the courtroom and we're arguing a position, we compare apples to apples. We don't compare apples to oranges. And when we compare apples to apples, we're supposed to get the same exact result. So what that means to me, when I listen to that prayer, when we talk about honest policy disputes, and when I listen to the prayer and we talk about working across party lines, which is very important to me, I believe in that principle. I believe that it's not about being only Democratic and Republican. It's about being humans. It's about being people that are supposed to work together, supposed to love one another. That's what I stand on. That's what I believe. When I hear that prayer, I say to myself, you know what? It's my prayer that you actually do that today. It's my prayer that you actually do that when we leave and you listen to Senate Bill 249. That's my prayer. It's also my prayer that the opportunity that you gave us today to come into this hearing was not an opportunity that you just gave to us so that you could pacify us. And I'm not trying to be offensive to anyone. These are just the things that I've heard, and I'm trying to be optimistic because I'm an optimistic person. Crossover Day is March 15th. We all know what that means. That means that if something is not done with our bill, Senate Bill 249, it's gone for now. I reiterate, this bill has been sitting untouched, without movement, since February 25th of 2001 until today. I want to end by saying that I understand that our district attorney is going to come in and oppose this measure, and I respect his position. I also want to remind you that when Senate Bill 9 was presented, there was a whole bunch of opposition. A lot. And this committee didn't take in consideration that opposition, did not take in consideration at all the empirical evidence that says that Senate Bill 9 should have been cast down and not move forward. I'm asking you to remember the prayer that you heard today. Honest policy disputes. And this is not one. And we're asking you to favorably support Senate Bill 249, get it out of committee as soon as possible. And I want to remind you, you have the tracking just like everyone else does on how a bill gets entered and when it gets approved. So I don't have to go into details on how quick Senate Bill 9 was approved. And thank you.
All right, thank you, Ms. Lindsay. A couple questions I have. Yeah.
Sure.
What was the vote from the Newton County Board of Commissioners? What was that vote?
It was
count?
it's 5 commissioners and there's a 3-2 vote, but it was the majority. And as you know, Chairman Strickland, the policy of the county is that anytime we have the unwritten, and we talked about unwritten documents, and that was very enlightening to me as an attorney when we talk about oral agreements. The policy is that when the resolution is presented, the resolution is presented from the majority, which encompasses the whole entire community.
That's whose policy?
No, that's just an unwritten custom. I'll put it to you like that. It's an unwritten custom.
What was the outcome of the vote in Walton County on the resolution supporting this?
I'm not sure.
There wasn't a vote in Walton County, was there?
I don't think so because it didn't have to do with Walton County. It was a Newton County bill.
Well, no, it actually would split the circuit
Yes.
and create a separate circuit for Walton County as well. You compared this a lot to Senate Bill 9.
Yes.
What was the local Board of Commission weigh in on the counties affected by Senate Bill 9?
I'm not sure, but I know what the numbers were. I know what the case study was, and I know that after the case study was presented, which I know this whole board saw, the case studies that were evaluated from 2018 and the most recent case study that was presented from 2020, and I want to clarify, it wasn't a study, it was an assessment, says
Hold
that
on.
Columbia County should not have had its own circuit.
Okay, you compared a lot to Senate Bill 9,
Yes.
but I don't think it's very genuine to do that when you don't have the same kind of local buy-in that we had with Senate Bill 9.
What
where
would
you
that have
had
been?
The local counties that embraced this, I believe it was unanimous. I think one county had one person that opposed and a second vote, but it was unanimous, and also the entire delegation supported it on both sides as well. And so you spent half the time comparing this to Senate Bill 9, but it's a completely different situation. You have one county that weighed in with a 3-2 vote, one county that hasn't set forth any desire to do this.
And they haven't set forth any desire to not do it formally.
Okay.
And so, and I'm respectfully, let me retreat, because I don't want to make it seem like I'm attacking you, and I definitely don't want to make it seem like you're attacking me.
I'm just asking questions.
And I appreciate that. You're part of our delegation,
Correct.
and you're familiar with the actual vote. You're also familiar with the desire of the board to move forward with this. You are also familiar with the fact that one of our commissioners who voted against it was not against it. He just wanted more time to look into it. Unless there's something formal that I'm not aware of, we have a resolution that has been filed on February 2nd of 2021. That resolution was presented by the Board of Commissioners, which is encompassing all 5, and it was signed by our chairman. And it was presented to our Newton delegation to move forward vigorously with the legislation that would allow for Newton County to be its own judicial circuit.
And I have a couple of questions. Some members have questions. What is the amount that if we pass this, how much would it cost locally for Newton County?
My understanding that locally, the costs, I don't know the details of the numbers, but I can tell you what the equation is. What it would be is we would have 3 judges that we would have to continue to pay. The state pays the majority of the judges' salaries, and Newton County pays a supplement. There are 2 other judges that are in Walton County. Those 2 judges that are in Walton County would continue to be paid their state salary, and then they would be paid a supplement that Walton County would have to pay that we won't have to pay. So there's a savings there. That savings is then put across where we would have to pay for the district attorney that we would have to have appointed, and we would also have to pay for the chief public defender that we would have to have appointed. And I left out the staff of the judges. There is a secretary that is paid by the state, and there's a supplement that's paid by the county, and there's a and there is a law clerk that's paid by the state and the supplement paid by the county. However, if we're not paying those on the other end with the other 2 judges, those savings would then go across the lines of the other individuals involved. But I can tell you that even those numbers pale in comparison to numbers associated with Columbia County have its own judicial circuit.
And how much would it cost Walton County? Do you know those numbers?
I don't.
And last question.
And
I'll
I would
turn it
assume
over
that
to-
Senator Tanya Anderson would know more details about that.
Yeah.
But again, just looking at the overall picture, the cost still would there's no comparison of the cost between what's spent with this measure and what was spent in Senate Bill 9.
Okay.
Would you agree to that? Would you agree to that?
Once again, you're comparing Senate Bill 9,
Okay.
where local governments bought in and asked for that bill, and whatever costs there was an agreement on that. Last question, do you know what it would cost the state then, since you're talking about, I think you said adding a new judge, and also, of course,
There
adding
would
a new
be an
district attorney,
addition of a new judge and district attorney.
and then a new public defender, whatever costs go with that. Do you know what that number would be?
I do not know what that number
Okay.
is.
Questions?
Again, that number would compare, in comparison to Senate Bill 9, there
Okay.
is no comparison. And I hate to keep saying that, but Chairman Strickland and other members of the board, you all are attorneys, or at least the majority are attorneys. And those that are not attorneys are doctors, okay? And so when you look at cost comparisons, when you look at policy comparisons, I agree. you have to compare apples to apples, and that's exactly what I did here when I compared Senate Bill 249 to Senate Bill 9. When you say complete buy-in, we have a community that wants this. We have stakeholders that want this. We had a former representative, Pamela Dickerson, that helped push this. And had she been here, she would have been pushing it, and you would have heard her pushing it. This is something that is desired by the community, and the resolution itself is an indication that this is something that the county wants.
Let's get some other questions in the committee. Senator Calzert.
Thank you, Mr. Chairman. If I could ask a couple. I'm uniquely positioned on this because I represent the 46th district in the Senate, which encompasses most of Walton County. And I practice law out of Athens, and frequently am in the Alcovy Circuit in Newton, Superior, and Walton
I've seen
Superior.
You.
I heard last year from the judges in Walton County that they did not want to split, and part of that came up in the context of some discontent in Athens and Oconee County, where Oconee wanted to split off of Athens due to not because of racial politics, but party politics. There was a new DA in Athens that did not want to prosecute certain offenses that are on the books. So we talked about putting Oconee into Walton and accomplishing what Senator Anderson was trying to do, and I caught very strong resistance from the folks in Walton County. Last night I got a call from Judge Ken Wynn, and he assures me that all three of these Newton County Superior Court judges, the ones that reside in Newton County, do not want to split this circuit. Even the ones that live in Newton County don't want to. What the public is perceiving this as discontent with a white Republican district attorney in Walton County winning the race last year. And he'll be here to give his views on that today. And I am getting extremely uncomfortable with the resegregation of our judicial districts. I mean, African American population spent half a century to get rid of integration. Segregation and have integration. And now we're splitting these apart. Last year we let it happen because the African American population in Richmond County wanted to be separate and have their own DA, and the largely Caucasian population in Columbia County wanted to be separate. I mean, we're having these separatist movements. This feels like a black separatist movement with Newton County wanting to be separated. And I don't feel real good being a part of this process, and I don't know what rules or regulations. What is that black voting age population in Newton County now?
They're voting at 18, and we have
I know that's their age, but what's the percentage of the voting population that are African American in Newton County?
It's over 50%.
And that's why I'm getting this feel.
Okay.
Last time it was almost we allowed it to happen because both the whites wanted to be separate and the blacks wanted to be separate. I mean, you could narrow it down to that almost, and both county commissions were all in for that. This one we don't have buy-in from the Walton County. It's almost like a secessionist movement for Newton County, the majority African American population wanting to be separated. It's just bizarre that we're going that direction after the progress that we've made over the last century.
Okay.
Is there buy-in from the legal community?
Yes.
Certainly which judge supports this?
Well, you said that you talked to all the three judges in the county, and all the three judges formally told you that they are not in support of that. You talked to Judge Wynn, who I love tremendously. I think he's a great judge. I think we have great judges across the whole entire bench. And like I said earlier, I know DA McGinley. I think that this is more so about policy. And I understand that Columbia County may have been about white, black, Republican, Democrat. And I understand that the perception that most are probably thinking is, oh, this is a white, black thing too. And see, that's the problem that I have. It's not about white, black. It's about policy. It's about representation. It's about the fact that if you have a community that is
You've already got 3 of the 5 judges. Newton County has 3 of the 5 judges in the circuit, so you got representation. You have excess representation.
But it's about policy. The judiciary is just not about judges and about judicial staff and DAs. That's not what the judicial circuit is about. To me, The justice system is about making sure that there is a partnership between the actual bench, the actual circuit, the actual system, and the people. The people have to have things that are needed in order for us to address the needs of the community. To give you an example, DeKalb County is completely different from Newton County, completely different from Walton County. There are judges and there are DAs, a DA and a solicitor in DeKalb County. Collectively, they look at what the needs are of the community as it relates to policy. Policy. Think about that. Policy. The policy in DeKalb County is not going to be the same policy as in Walton County as it comes down to the judicial system. It's not.
The laws
It's going
are
to be
statewide. What are you talking
It's
about?
not the laws that are the issues. It is the sentiment of the people, the engagement of the people that make a difference. You want people to feel like they are connected to any system of government, including the judicial system. That's not an exclusion. That's even more reason for you to look at that, because when we have reoffensive rates, when we have rates of repeated incarceration and generational curses, we can't just sit by idly as a judicial system and not address it. You have to address those things. And if you don't feel like that is an issue in your community, then that's a problem if it is. What I'm saying to you is that when you look at policy, and I see you may be a traditionalist, I'm not. Because in today's society, with the millenniums and the kids that are coming up, we have to do things aggressively different to save our communities. In Newton County, and it's not the fault of our justice system at all, we had a series of drive-by shootings, okay? When you have a series of drive-by shootings like that, you can't just get to the point where you just want to just arrest people and put people in jail. You have to get to the root of the problem. And the root of the problem is deep. And what I'm saying is that you have a group of people in our community, stakeholders in our community, like Harold Cobb, stakeholders in our community, like a part of the NAACP, Archie Shepherd, all these individuals that were concerned about how we address where our community is going, okay? And the way you address that is a policy from all aspects, including the DA's office, including the judicial system that will address those needs. And what I'm saying to you is that without a doubt, Walton County is diabolically different than Newton County, 100%. And sometimes you cannot have, if you have a structure that is governed by the majority, that majority doesn't feel like those policies are important or those policies are necessary. And what I'm trying to express in the best way I can in answering your question is not only about white and black. It's not about Republican and Democrats. It's about the needs of a community. And our needs in our community in Newton County are different from the needs of Walton County. The resources that we share, if there's a means for us to divide those resources so that we can divert those resources to the things that we need in our community, that's what we want. Let me tell you something. People that know me know I could care less about politics. I'm involved in politics not from the standpoint of let's win, win, win. I'm involved in politics to affect a change. That's what's important, and that's why you all were elected, to affect change.
We have a couple of questions. Senator Hatchett.
Thank you for bringing this. Has there been a boundary study done?
There has not been an official study done, but there have been preliminary studies that have been done. Just like there were preliminary studies that have been done on Columbia County. And I understand that Chairman does not like for me to reference Columbia County, but there are studies that have been done on Columbia County, and they were absolutely nowhere near the point of being able to have its own circuit. We are at the point where we need our own circuit.
Well, has there been has the Judicial Workload Assessment Committee looked at the case study for the number of judges? I'm just, I'm curious as to why Walton County would get 3, or excuse me, Newton in your proposal would get 3 and Walton would get 2. How is that going to affect the caseload?
That's not my proposal. What that is the study. This based upon the study that has been done, and I don't want to use the word study, so you guys will start using the word study. It wasn't a study, it was an analysis. There's never been a study done for Newton, and there's not been a study done for Walton.
Well, I know.
I mean, for Columbia County.
So recently, in my circuit, there was a request for a third judge, and we had to go through a long process. And the Judicial Workload Assessment Committee, they look at 3 years worth of cases.
Yes.
They look at how many cases each judge has. I think that's important information to have when you're taking a circuit that has 5 judges and decreasing it down to 2. And I understand, I understand your position completely, but from I'll use the word logistics, a logistics standpoint, when you're talking about breaking up a circuit, and I would have a hard time voting for anything without seeing the numbers in each county, the cases, the judges. I just, if we were splitting it 50-50 and the cases were similar in each county, that'd be one thing. But I really would like to see that, and I think
I have it. Well, Senator Anderson has it, and you're free to get it. If the way that the analysis read was that if there was a split between Newton County and Walton County, based upon what judges are in place right now, Walton County would end up with 2, Newton County would end up with 3. However, it would put Walton County where they would need an additional judge, one additional judge, and that's what the analysis revealed.
Is that from the Judicial Workload
It
Assessment
is.
Committee?
Yes.
So that study has been done.
It's not a study, it's an analysis. And see, the reason I don't say study is because we use study too loosely. There's only one study, and that's a very comprehensive study. And we haven't had it, Columbia County didn't have it. But there has been preliminary analysis, which is based upon the study guidelines and the study requirements. There are certain things that the study that you're referring to takes into consideration. They take in consideration the population. They take in consideration the caseload. They take in consideration the traveling for the judges in the various areas based upon where the judges live. When they look at the full circuit, Okmulgee Circuit has several, well, they don't have several judges, but they have several counties. They take all that in consideration in the study. In analysis, they take like a preliminary review of that information and give you an assessment. And that's what's been done for Newton County and for Columbia County.
One more question.
Yeah.
So right now you're saying if it were to split, Walton County would need a third judge?
That's based upon the assessment, Walton County would need a third judge.
Okay.
Senator Jones.
Thank you, Mr. Chair. And I have a couple questions, also a couple comments, just because Senate Bill 9 has been referenced so much. But just to kind of put it in perspective, you said that Senator Anderson had these numbers. For Richmond County at the time, because I also want to push back about the idea was segregation. Richmond County at the time, 80% of all felonies were in Richmond County. It was a caseload management situation that existed. And I mentioned that when we went to the well. And our clearance rate in Richmond County was less than 50%. So we needed our own circuit, not just from the standpoint of being an elect. And the idea was myself back in 2004, and at that particular point in time, we were not going to be able to elect an African-American DA or African-American judges. So it was initially brought up in 2004, and race was not the reason, because even then Richmond County was bursting at the seams. But that also brings me up to, you mentioned Representative Mumford back in 2008. I would imagine the demographics were different. And at that time, they actually wanted to split the circuit. Is that correct? 2010,
they requested, he spearheaded the endeavor to split the circuit from Walton County.
And one of the reasons was, I read an article about it, was it not because they basically were bursting at the seams as far as the caseload was concerned?
That's correct.
So way back in 2010, probably before the demographics even changed, there was a request to do this based on numbers.
Yes.
And also, I would make note that even with Senate Bill 9, all of our judges in Richmond County and Columbia County, those who lived there, they were also opposed to this. So is it not accurate to say judges are usually kind of opposed to change to some extent?
Yes.
Because our judges were also opposed to it. But I do, and I guess you say Senator Anderson had the numbers, because that does become important, especially when you do want to do the Senate Bill 9 comparison, is the caseload numbers, because that was important to me as far as doing this. Also, the clearance rate numbers. Those are real numbers that do suggest whether a circuit should be split. And how do the counties view themselves? That was another reason that I presented this, that Richmond and Columbia County don't view themselves as one big county. We're two separate counties with two separate identities. And maybe you could also speak to that too. And then last, how would y'all compare to other single county circuits? The fact was Columbia County would be one of the larger single county circuits, and Richmond would too. We were the largest multi-county circuit in the state. How do y'all compare as far as that's concerned, as far as size of multi-county circuits, and also how would y'all compare as far as being a single county circuit as other single county from a population standpoint? If y'all could provide those numbers, would also be an accurate comparison too.
And we have the numbers. I actually provided some of those numbers to our delegation already. The caseload study, I went on the administrative courts website and made requests for additional studies, data. That's the better word, data to provide to our delegation so that they could be fully informed and be able to compare to see what the needs were. So we can definitely get that information out there. And to answer your question about identity, I think that identity is such a strong word. And nowadays, we can get in trouble and get sued for misidentifying or, using the wrong pronouns when it comes to people's identity. And so when you talk about the identity, when you think about it, you compare Walton County to Newton County, the identities of the counties do not merge. They're separate and distinct identities. And I can provide you more information, and I'm pretty sure if this is going out there, then the community can provide you more information about the different identities of the two counties that are involved.
All right, thank you, Ms. Lindsay. Those are all the questions from the committee. Appreciate your time today. We have one other speaker you referenced.
Senator Anderson hasn't.
She's not in here yet, but
Okay.
But when she gets in here, I'll call her up.
And I think that Mr. Wills, I don't know if it's too late for him to put his name down on the list, but he wanted to also speak.
All right, I'm gonna go on the
Yeah.
list first. We're gonna be a little bit limited on time as we start to lose people, but let's, next person up to speak is Randy McGinley, the district attorney for the Alcovey Circuit.
Good morning.
Good morning.
Chairman, and I was say this might be afternoon, but I'm Randy McGinley. I'm the district attorney, the elected DA in the Alcovey Circuit, and I represent I think about 212,000 people in this circuit in both counties. To kind of go along some of, and obviously I'm here to oppose this circuit split. I don't think financially, logistically, procedurally it makes any sense whatsoever. I think some of you have already hit on those, some of those reasons. I'm not going to belabor that. I will point out that Columbia County, Newton County, according to the last census, which was just a year or two ago, was 112,000 people or so, and Walton County was right about 97 and some change, just under 100,000 people. That puts Newton County at 35%, Columbia County being 35% bigger than Newton County and 50% bigger than Walton County. We are already, with our 5 judges, we're at 15% lower than the state average population per judge. I honestly don't know what the difference is between a study and analysis and data are. The AOC has done a study, I'm going to call it that because that's what I think it is, that looked into this. Senator Anderson requested that study to be done by the AOC. They looked into 14 different scenarios. They came up with 2 that would work under their guidelines. None of those involved splitting the circuit. They actually involved adding counties to this circuit. One of them was to add Morgan County, which is from the 8-county circuit next to us of the Okmulgee Circuit. The other was to merge the Western Circuit with the Alcovey Circuit. Now, there's obviously, I don't know legally if that's constitutionally viable because you'd have to remove a DA from office. I don't think that's...
What's the Western Circuit? Which county?
That's Clark and Oconee County. And like I said, I don't, there are research at issue, but I would assume there's some legal issues of removing a DA from office when you merge 2 circuits. So, but under their guidelines or their things that they look into, so the only legally viable in my mind scenario they looked at would be to take Morgan from the Okmulgee Circuit and add it to the Alcovey Circuit, not to split the circuits. And I will say, as the AOC study, and I appreciate their study, it is limited to a certain extent because it is looking at judicial workload only. That is only a small picture of that. To say that this is not going to cost anything otherwise is, I think, disingenuous. The judicial staff, as Ms. Lindsay stated, and I appreciate her comments, was that the judicial staff, I think, is about 16 total people. That's 5 judges, 5 clerks, 5 secretaries, and 1 additional staff member in Newton County. The DA's office alone is about 63, 64 individuals. And we work and have cases in both counties. Obviously, as a DA, I go back and forth between the 2 counties. We have accountability courts that are just open in 1 county. We have a drug court, which I know this body and the legislator and the government in general here in Georgia has been very supportive of accountability courts. We have a drug court in Newton County. We do not have a drug court in Walton County. But Walton County residents apply for and enter the Newton County drug court system. Veterans Court we have in Newton County. We do not have in Walton County. Defendants that are charged with crimes in Walton County and reside in Walton County can enter the Newton County Veterans Court. There are going to be issues when you'd have to set up separate drug courts in a separate drug court in Walton County, a separate Veterans Court in Walton County if people wanted that. That's a huge cost. I know Chairman Strickland kind of stole a little bit of my thunder that I think the proponents of this bill spend more time than anything talking about Columbia County. This bill has to rest on its own, in my mind. But with that, I think the Columbia, my understanding from folks with PAC is that the Columbia County circuit split costs the state about $1.3 million. To say that it doesn't cost a ton of money, I think, again, is disingenuous. It is going to cost a lot of money. That excludes all of the other things that are involved in the DA's budget, the public defender's budget that are shared between the two counties. There's a number of software things that we pay for that are shared between the budgets between the two counties. The public defender's office currently, as I think this committee is probably well aware, that public defender's offices and DA's offices across the state and across the country are struggling to find attorneys. It is a shortage that is a problem everywhere. The public defender's office is not immune from that, neither am I. But they are currently having one public defender that's going back and forth between the two counties to handle juvenile court because they can't find anybody to fill those. Obviously, if a circuit is split, the state currently pays for the DA, a chief ADA, a drug court ADA, an accountability court ADA, and a juvenile court ADA in every single circuit. That's 5 DA positions that cost a ton of money to the state. And again, as Senator Cowsert pointed out, the judges are against this. I will get to the point briefly about there was a resolution that was passed 3-2. I don't think that is in any way showing that there is the will of the people wanting to do this. There's a slim majority. And the resolution was put on the calendar literally that afternoon before it was voted on that evening at the Board of Commissioners. There were no chance for anybody else to speak. None of the commissioners spoke to myself as a DA. Not a single judge was spoken to, not a single clerk of court. No one with the public defender's office was spoken to at all about this resolution. This was something that was done very quickly and I think very slyly, in my opinion, to try to get it passed as quickly as possible without much public support or discussion. I think this committee, I forget who asked the question, is there support from the legal community? There was yes, but then there was zero. There's some amorphous people apparently that I'm unaware of that are supporting this. I don't know who they are because everybody I've spoken to, and again, as Senator Cowsert pointed out, all the judges are against this. I don't think this makes sense logistically, procedurally, or financially. I'm more than willing to answer any questions that this body has, but I'll kind of leave my comments at that.
All right, any questions from the committee? Senator Cowsert.
I want to point out one thing for you personally, Randy McGinley. Politically, this would be wonderful for you because you reside in Walton County, you're Republican, and had overwhelming support there, and Newton County is majority Democratic voting pattern.
Yes, I mean, Senator Cowsert, I think I won Walton County by 75%. I live in Walton County. My daycare is 3 minutes from the Walton County Courthouse. But again, I was elected to represent both counties and all the people in those counties. Now, I lost Newton County, but by, I think, 10, it was 55-45 or so. So it wasn't some overwhelming majority in Newton County. So yes, you're correct. It would personally make my life very simple.
And you still think this is not good for the circuit as a whole?
Correct.
Thank you.
Any other questions from the committee? All right, thank you.
Thank you.
If you want to come up real quick, be our last speaker on the bill, if y'all can stick. I know you have to go. But if you'll introduce yourself for us, I'll turn the floor over to you. If you can try to keep it within just a few minutes, if possible.
Okay. I'm going to try.
Yes, sir.
My name is Gene Wills. I reside in Newton County and have a vested interest in what's going on right now. When I look at the voting for Randy McGinley and Destiny Bryant, I see that he would have lost if he would have ran just in Newton County. He's not representing our county. His values are different. His the way we feel certain people are treated in our county, we're not okay with it, but it appears that Republicans are. Destiny received 8,119 votes from Walton County. She received over 29,000 from Newton. McKinley received 23,000 from Newton. We feel as though we don't control our own destiny. We don't believe the system is fair. And Walton County interest is very different from Newton County interest. We're growing at a fast clip. We got more than the Rivian electric car manufacturer coming. We have Three Ring Studios. We have Lindell's. People are going to really start populating our county of all walks. And on top of that, we're a Democratic county that is being controlled by the minority. I feel it's not fair. We should all be able to control our legal courts and who we vote for to represent us. Destiny had some good ideas, decriminalizing marijuana and other things, and shorting the probation terms. It seems like African Americans or poor people who can't afford a good lawyer get these outrageous probation terms, 10 years probation for shoplifting or something. I'm just asking you to consider that we are growing. We are a Democratic county, and it's just going to become more and more Democratic because of the different types of manufacturers and companies coming. We want to be able to be fair to our people and our community, all people. To me, this is not about black and white. This is about being human beings and using common sense. If Destiny only received 8,000 votes from Walton County, yet Walton County basically controlled Newton County, that's not fair. And that's basically what all I had to say.
And so Destiny Bryant is
Yes.
the person that ran against the current district attorney?
Yes.
And so different from what Ms. Lindsay said, it sounds like your main goal with this would be to be able to elect a Democratic district attorney for Newton County.
To elect a district attorney that reflect the ideals of the constituents of Newton County. It could be a Republican. It's what they're saying in their campaign speeches and their record. What does it promote? So we're looking to help everyone be more successful in Newton County, have a chance for prosperity. And we've seen all the hatred and things from all over the country. We see with cops waiting for a racial war. That's not us.
All right, you have a question from the committee, Senator Jones.
So let me ask you a question to kind of lawyer it up a little bit. Are you basically saying that you think that the way the current circuit is configured, that you might have a situation where the African American vote is diluted on some level from a voting rights standpoint? Is that what your argument is?
It's nullified. It's nullified. And Democratic, not just African American. Anyone who calls himself a Democrat, I don't know if every Republican is white and every Democrat is black. I don't think so. We got a good mixture of people who want to be fair to everyone. They want everyone to vote. The only one who claims that the voting system is rigged is the people who cheat. So, anything else?
All right, any other questions from the committee? All right, thank you, Ms. Wills. Does Senator Anderson, did she arrive? All right, that's everyone that signed up to be heard on this bill. That completes our agenda today. With that, we're adjourned.